Sorry,
R.
thanks.
Alt R.
Yeah,
oh, no,
I got it.
iPad.
Got it.
Okay.
Thanks. So sorry, coming back to this, we've got the policy reason behind it. We've got a solution with video, and I just don't envision the counterparts clause being provided in anything more than just an add-on to the existing. So if we've done that, and I think it's pretty exciting if we, and we're, as I say, we're confident it's going to happen, because this does resolve the health issue. It doesn't resolve a little bit of a headache for us in the sense that we're going to have probate applications that are going to be a little more paper intensive. These wills will be, in some cases, triple thickness. So the control of the documents is going to be very important. And I just wanted to speak to that briefly. So Suzana, if we get into a situation where we do a counterparts for signing, which has been described by Jordy, and as I say, we'll put up a resource link to this as soon as the legislation gets passed, which I would think, I'd be surprised if it wasn't done by the end of this week, but early next week would be almost certain. The question of the custody of the document, and we see this in lots of cases where we're dealing with lost will cases and so on. What would be some of the things that you would be watching out for in a counterpart signing, Suzana, in terms of making sure that the document is the actual document that the testator is signing?
Well, I think during the actual execution process, we're going to want to make sure that it is the same document that everyone's signing. And I know Jordan's spoken previously about, keeping a little tagline on the document so that when it's printed out by each of the persons who are going to be signing, that it reads the same thing, that it is the same document, because it will be a question of evidence as to whether or not, it was the same thing that everyone was signing. If it's held up to cameras just to, during the course of execution, that'll help too, I think.
Absolutely. All right, so just a couple of questions that are coming out of this, Jordy. Now, do you think once the counterparts become an option, they'll still be able to continue with the current method where there are multiple consecutive video calls, one copy rather than one video call and multiple copies?
I do. I think you'll have that. You'll still have that option to do send around what one document that has the wet signatures of all. I think that this is just another option. It's a permissive. I mean, we're guessing, of course, but educated guess that it's going to be permissive.
Yeah, and I think that's what the government's trying to do, is just keep giving us an arsenal of abilities to affect signatures with wills. One of the questions, and it's something that you and I have already talked about, and Suzanne, we've been noodling on how to, do we need a counterparts clause, or how are we going to deal with the juriat, and how are we going to deal with the affidavits of execution? Jordy, do you want to start with your thoughts on that?
Sure. So I believe you'll need separate affidavits of execution, different ones, that is, by counterpart. So I know we've been working on that together. So when the legislation is passed, we'll make that available to everybody, and to any e-state users, they'll be available in your portal. So it'll be automatically generated. And then there's the whole question of what should the testimonial attestation clause say. And I think a reference to the fact that it was witnessed by video in counterpart, because in this case, right, to anybody else, this is going to look different than the previous one, and it would not maybe be consistent with the current, the sort of standard attestation clause. So I think in this case we may actually, whereas maybe in the other one we didn't, in this one, because everybody will be able to see that it's signed on different pages. So I think in that sense, you would require a new attestation clause.
Yeah, it's unlike the other scenario where we had a debate last week about what do we have to do with the clause in the context of a will, and are we going to change it when it's a video? And we sort of landed on the fact that when you're doing a video, the key really is to identify the unique circumstance of signing only through the affidavit of execution so that we don't affect the impact with third parties. But as you say here, it's going to be a very different looking document. So I think we have to face that music, and we're drafting something up to address that, to reflect the sensibility of it. All right, now, so Jordy, do you have any other initial thoughts in terms of some of the practical steps?
Yeah, I mean, the big key is that, you know, you'll want to send around, obviously, you'll want to send around the document in a form that can't be edited or makes editing more difficult. So a PDF version rather than sending it to a client in Word where, depending on their printer and other things, it can get printed out in different pages. You want to make sure, if we can, that we're dealing with it on the same, you know, unchanged version. And the other thing, and I think Suzana, you made the great point of making sure that the document has a unique identifier. So typically I'd put that in the footer, which has not only the document name, but the date and time that it was generated, so that you know, it's a little bit more specific than just simply the name of the file, but that it's, you know, that everybody, okay, we're all working on the will 2A done on, you know, April 24th at 11, you know, 24 a.m., that kind of thing.
So Jordy, just to take that one step forward, and there's a great question on the chat about this. Just to make clear too, also, although I started recording a little late, we'll be putting this up on our webpage. So this discussion will be available for us to listen to again, or others to listen to. What about, how does this, if we get to where we're going, and that is the counterparts clause, how does that affect, or what impact does that have on incorporation by reference with a holograph will, and how would the two interplay? The question is, does incorporation by reference with a holograph look a lot more attractive now?
I'm not sure, to be honest with you. I haven't thought too much about that. I'm thinking more that you might not need that, to use that technique, especially when its authority is not clear cut. And I think maybe this is the solution for that kind of problem, where we had the problem where we couldn't get witnesses, right? There was no way to do it, and courier things back and forth, and that was, you know, a problem. So I think this might actually make that option. I'm not even sure if this might just solve that problem, but I haven't thought too much about that, so I very well could miss the entire issue there. Sorry.
No, it's good. Listen, we're blessed with tough questions. Go ahead,
I was
Suzana.
just going to add that with the things that we're seeing, and from like a reasonable standard, I think the standard of care for lawyers when we get questioned and get held to a standard at the end of the day is, what were other people doing? And if there is a standard practice amongst all of us that we're doing more of the counterparts or the other means by which these wills are being done, as opposed to the incorporation by reference or what have you, that it may help us as a group to say, you know what, a lot of other people were doing with it, it was reasonable, and therefore we should be held to that standard, as opposed to perhaps taking a chance with something that may not ultimately work, although we are still hoping that it will.
There's strength in that. That's a great point, Suzana. There's strength in numbers. Yeah, I'm going to be looking to my colleagues as well to see what they're doing, because, yeah, your point is excellent about the standard.
Yeah, and I think just in terms of that and expectations that we're faced is this, I believe that we, in this process in COVID, and we will get questioned, and there will be, contentious proceedings that come out of this at some level. To the extent that we can enhance our checklists and that we can show that we followed our checklists on these unique steps is also going to go a long way. So whether you use our checklist or you create your own with the step of a video, or you step with a holograph, or you step with the counterparts clauses. If I've got it in my file, even check the boxes, identified it in the video, if I'm recording it, going through the checklist carefully, I think it's even more so than normal, a rigid compliance with this new arrangement is actually going to be expected. I mean, you know, haphazard sort of loosey-goosey efforts on this stuff is not going to be, I don't think it's going to be tolerated, because we're being given a special privilege. Will execution has been, the rules have been around for, you know, since the 1200s, and in Ontario since the early 1800s, the legislation's been there. And so these are hard and fast rules. And the fact that we're getting some expansion of those rules for a very legitimate time and reason doesn't just, you know, sort of exclude us from criticism, and it doesn't give us an excuse. So, you know, I'm using that I've enhanced my checklist because of that, because I know I'm going to be scrutinized. And an easy answer is, hey, look, I followed what the practice appeared to be in the circumstances of the pandemic.
Can I just make
so,
a point, just one point on that, Ian, is it's even more challenging, especially if we're not meeting with clients in person, that you know, it's going to be easier for a challenge to say, look, you know, the client didn't understand, they were on the phone, it was hard to, we all know that's harder. That is, no one's going to dispute that it is not optimal way of taking instructions. And so, you know, the more we can, you know, alleviate that issue, we may have to work harder, in other words, because of this on those fronts. That would be my concern there.
I totally
think it's important
agree.
because we're all pushing. Oh, go ahead, Suzanne.
I was just going to follow up on Jordan's point. I totally agree, Jordan. I think we're going to be held to quite a high standard, relatively speaking, in the sense that we're so caught up on, you know, the mechanics of having this will signed, and we want to maintain the whole sanctity of the entire will process, the will instruction taking process, because we can't get lazy. We can't be too forgiving because of the circumstances. I still think we need to do what we would always do if we had a client sitting with us in our office and, you know, probing, verifying, and testing for capacity, testing for situations of possible undue influence, all the same things we always had to do, and not just get too caught up on the actual mechanics of the due execution.
Yeah, that's so crucial. And I think we want to talk about in the second half some of those in more detail, Suzana. So thank you. All right. So as far as we had some good chat points here, and I just want to keep following them along because, you know, it's one of the points too is that this is an evolving situation, and we're trying to follow standards that are being set by new legislation and by the practitioners. But one of the questions that I'm being asked, and I think it's a good one, is, Jordy, maybe we can start with you, is that what's going to happen when we come out of this? Are we going to say to clients, come and re-sign? And if so, will there be additional charges? What do we do if the client doesn't re-sign? What are some of your thoughts on that?
I would encourage probably my clients, especially depending on the circumstances, to re-sign. It's just going to make it easier. I mean, you know, it'll be valid if we follow these rules and all of those things, but it's, you know, the probate application with 3 copies or however many copies, you know, not optimal again. It's a great stopgap measure, and it'll be effective, hopefully. But yeah, I would probably encourage my clients to come back and re-sign. That's just me. I don't know about charging them to do that. That would be up to you. I'd have my call on that. I don't know. I don't think I would, but that's not, I mean, that's completely a business decision, I think. But yeah, in certain circumstances, I probably would want to just for ease, you know, and make it a little cleaner.
So just to be clear too, I think you and I and Suzana follow it closely as Practice Pro. We did before, but now even more closely. And I certainly get the impression that Law Pro is strongly, or not strongly, is encouraging us to have re-signings. And my view is going to be that I'm going to encourage them to come back. I won't charge them for the re-signing, but if they want to revisit the estate plan in any manner, then it's a fair game to reinstitute a proper retainer.
I read that differently. I had Law Pro recommending that we all resign, but I guess maybe I was just misreading that. Okay, got it.
All right, good. We got a little humor. This is not easy on the live chat. Okay, so thanks, Natalia, for raising that point. Okay, so now let's just spend a few minutes, and I think that the beauty of the fact that this counterparts provision is going to come in is the simplicity of it. Let's spend a few.
Somebody's sharing their screen.
Oh yeah, so when someone's gone in and screen shared, if you could just remember, if we can, just go off of, turn off your video and your mute.
Hello.
Thanks. Yeah,
there we go.
Thanks. I think they're about to. Okay, so while the screen sharing issue is going on, we'll introduce the next topic, and then Jordy, I think we need you to screen share. So
yeah.
We'll
so Ian, can you? I think you can stop that screen share.
Okay.
I think we can figure out who that is. We're not going to announce it. Oh yes. LM. Yes. Can you see the name at the top? LM Rumac. Yeah. Could you stop sharing your screen?
I'll try and turn it off completely.
Okay.
Thanks so much. Yeah, just hit mute and hit stop video at the top. I don't know how to do it on my end, but I can. There we go.
Yeah, there's a share. If it says stop, it'll say stop sharing.
Okay. All right. So look, as I'm doing that, it's not seeing. I've lost
if you go to Zoom, yeah, there we go.
It's gone. Okay, great. Okay, so now let's spend a few minutes touching on the topic that Suzana raised, and feel free, everyone, of course, to throw chats at us. This idea that we've now got what I would say a plethora of options. It used to be pretty straightforward execution, but now we've got a plethora of options, including the codicil, including the corporation by reference, including the video, and now with counterparts. So let's, for the moment, pretend that we've kind of got through the headache of execution now, because we have so many options with our clients. We need to, I think, refocus a little bit and come back to what are special issues, what are special circumstances that we want to try to identify because of the video element. So whether we're video signing or video intake, or you know, the first your initial meeting might be by video, your signing might be by video. It's a different forum, and so whenever you create a different forum, cues and social cues and things like that, eye contact, all of those sorts of things are very different. So Jordy, let's start with some of the special circumstances, both from the client perspective and from the beneficiary or family's perspective. And then Suzana, if you could help us just make some comments as we go along.
Sure. So let me just.
Sorry, just to be clear, it's re-signing, not resigning. Although the joke was good, Jordy, there is some confusion. So
oh my God,
we're suggesting that people re-sign. Okay.
Sorry, guys.
No, it's good. It's a good joke, but you know, sometimes Jimmy Kimmel stuff is hard to follow.
Yeah, sorry about that. It is. Yes. Thank you.
Okay. So Jordy, let's talk about special circumstances and when you're in a video situation, sometimes you don't see the social cues. So what are some of the checklist tools that you consider and how best to manage them? And then Suzana, I'd like to just, as we go through them, just have some comments from a litigation standpoint.
Sure. So the special circumstances checklist, obviously, if any of these are positive, are yes, then you're going to want to drill down. But the ones that I want to just check on from a client, this is the client, the testator. First of all, vision issues. You know, can the client see this is important at execution, but it's important as well if you're exchanging any evidence, any visuals. that they can see what you're talking about. And it's also good to note, all of these are more important, obviously, in a higher risk situation. I mean, I don't care if my 40-year-old clients wear glasses, but if my 95-year-old client is not wearing glasses and is legally blind, then I'm going to want to know about that. So that's the first one.
Okay, so sorry, Jordy. Let's just we got the list up there, and there's a lot of people are phoning in too. So we just, some of the, on your checklist here, we've got vision issues, hearing issues, cognition issues, communication issues, health issues, and other issues. And then we'll talk about relationships. So Suzana, maybe we can just have you give us some overview observations on some of those special circumstances from your perspective, as we've all litigated on all of these issues.
Yeah, for sure, Ian. I think it's really important that, as I said earlier, that we really remember that we have to do all of these things during the course of these meetings, and even more so in more depth perhaps than before, because of the fact that the circumstances are so special. And I think it'll just make it perhaps easier for people to challenge things at the end of the day because of the novelty of it. So to the extent that we have checklists, that we're applying them, and that we're documenting the fact that we've gone through them and made these inquiries, I think it's particularly helpful to overcome any of these allegations that, we didn't do what we should have done in the circumstances. And Jordy's checklist right there, having it sort of front and center with the client on the screen, I think just really makes it so much easier to make sure that not only that it's done, but that it's done properly.
So let's talk about some of these individual issues from your perspective. I mean, you and I both been involved with cases where after death, issues of vision and hearing are raised. Cognition's obviously a main issue, but let's just talk about these physical ailments of vision and hearing. What are your thoughts in terms of protection measures that we can take at the intake level?
Well, that we are making those inquiries that, do you wear glasses? Do you normally wear them? And you'll see whether or not they have them with them now. And if not, why not? Hearing issues, can you hear me? You can probably get a sense from the dialogue or the exchange that happens on the video as to whether or not there's something blatantly difficult in terms of whether someone's having a hard time processing or hearing the information that's being relayed. I think the technology, we want to keep in mind that, there's always glitches. We see it all the time. So when we hear something that doesn't sound just right, was it really a technology glitch, or was it perhaps an individual not understanding or not hearing or not being able to convey what they're trying to say? So really just that awareness that the situation's different, and watching for these cues in a much more attuned way than we would normally be used to doing so.
And I think that's the key, is just ask the direct questions as well. And document that you've asked direct questions. Do you have hearing aids? Do you have hearing issues if it's the right circumstances? All right, cognition issues. What are some of the cues and some of the observation tools that you want to consider in a video intake situation or video execution situation? Less so in execution, because by then you've already had done the intake for cognition issues, Suzana.
I think it's very similar to what we would do with someone sitting across from us in our offices, and just being attuned to what comes out of that. Because as I said, I don't think we should be too forgiving of the technology or too lax in the circumstances. So you're going to want to delve into these things. If there's someone who's particularly elderly and you have concerns of some sort initially anyways, or even during the course of the meeting, we will many times, pause a meeting and say, what, in these circumstances, or just out of an abundance of caution in order to protect you and to protect your estate plan, we would suggest perhaps a capacity assessment being done. And I recognize that that might be a little bit difficult in these circumstances, but to the extent that we're making these inquiries and documenting things and really trying to satisfy ourselves as much as possible, I think that's sort of the best that we can do.
All right, so one of the steps that Jordy, when you get into the intake piece on the communication issues, when you're in a video environment, what, if anything, are you doing differently to address communication issues?
Sorry. Cool. So I think that, the test, the probing especially, is the same on video. This is one of the downsides to video and recording of any meetings. The fact that sometimes clients don't sound that coherent necessarily, and if picked apart, it could, there is that risk, right? I mean, that is a risk. Now, so I think we have to, do our best to test and probe, and you have that recording. Now, you don't have to have it recorded. That's the other thing. I mean, if you don't have to have it recorded. So, but I think that the same sort of probing about medication on cognition. One of the questions I always ask is hobbies. What do you do on a daily basis? Tell me about your day. Oh, I read the paper and I watch the news. Oh, I love that Trudeau, or I don't, I can't stand that Trudeau, or what. Anything that shows, I think, that the client is in the here and now is helpful, to substantiate capacity. I think that's going to go a long way. If they're playing bridge, online, or they're, reading the news and things like that, those are all, issues that, and now or before, what they're doing on a daily basis, I think, is an important question to ask, in my view.
All right. And so, Jordy, when you're, talk to me about your recording steps. So how are you introducing the idea of recording with Zoom now and video and intake?
I just explained to the client that I say to them, do you mind if I record this? Or I'm recording this, do you have any problem with that? And in most vast majority of cases, clients don't have a problem with that. Some often joke, oh, I better be careful what I say and those kinds of things. But I say, look, rather than just taking notes, I'd rather, have a recording, and then, you can watch, if I do allow them to do it, depending on what I'm doing with them. I have a record of it and those kinds of things. And that's what I do. In most cases, I don't have any objection from the client on that.
What percentage are you recording now with your intake?
Close to 100%.
And what did you do before?
Yeah, historically I didn't record, and this applies even before COVID. But historically I didn't record. I would just take notes like everyone else, and I just found that my notes were lacking. I had a difficult time both in engaging the client, taking notes, keeping my head focused on what I was supposed to be doing, worrying about what do my notes say, are they accurate, and so I found that it was useful. And then I could go back and say to my, when I forgot, I couldn't remember why did we do this? What was our discussion about this? Well, I could actually listen to that discussion. And so that's why I do that now more routinely. I mean, maybe we'll see more of that. I know I'm not in the majority by any stretch.
Yeah, but I think there's a much more acceptance of the videoing or recording the videoing and the intake than there was before, for sure.
And do you find, Jordan, that the meetings are now longer when they're by Zoom as opposed to when they were in person?
Getting them set up on Zoom usually is the first 10 minutes of the meeting. Hello, can you hear me? Can you hear me? Can you see me? I can't see you. I can't. So once we get past that, yeah, I think to some degree they're a bit longer. Again, I use the visuals, so that kind of keeps us on track. But so I don't see them necessarily that much longer. But sometimes the technology is what causes a bit of, I can't hear you. Can say that again, or I'm getting an echo, or whatever it might be.
All right. So Jordy, sorry, Suzana. Jordy's given us some, and we're going to come to the family side or the beneficiary side of special circumstances in a minute. But one of the questions that's raised is, do we have any tips for mitigating the risks of undue influence for elderly clients who need help from family members to set up the video call?
That's a great question, and one that I think we should always keep top of the mind when we're doing these calls with our clients, especially if they're, it seems that they're somewhat susceptible to influence. we've seen lots of checklists that people are preparing, and I know we've got one too that takes you right through to the beginning. Let's see the circumstances in which the conversation is being had. Could you, if possible, show us a 360 of the room that you're in? Who else is in the room with you? If there is another person, why are they there? And to what extent, is it necessary that they be there? And should there be moments in time when they're not there? And I think practicing what we would normally do, but just being aware of the fact that, we can't necessarily confirm it, is something that we should be cognizant of.
And I just did one recently, and I had, the old dog barking in the background, of course, is the life of our new, our world. But I had I was signing, it was a young woman and with a young teenage kid, not teenage, in the 20s, so it was an adult kid, comes, and I said, look, I've just got to sign your will up. We've done your husband's. I did her husband's at his office through video, and it's a mirror will, so standard, it was not funny. And I said, but you and I just have to meet, and I can't have your children around, the beneficiaries in the will and all that. And so I've got it videoing, and I'm going through the whole process, and this kid just walks into the room on the video. So I was like, okay, that's kind of evidence that he was present at the signing. So anyway, we redid it in another room, and I walked through all the same steps again, but it was pretty funny. And I just said, can you please not come into the room? He went upstairs quietly. It was a big enough house that he was a long way away, but it was sort of silly because it wasn't a situation of any consequence, because it was a mirror will, the husband and then to kids. But it was funny. The video, you don't have full control over your environment with video. Okay, so Jordy, let's talk about.
Sorry,
Sure.
And just one other point about just the circumstances that we're in right now. I mean, that in itself is giving rise to concerns about undue influence, not undue influence, but influence and capacity, and the underlying anxiety that this whole COVID is creating for elderly people. The fact that they're isolated if they're in a nursing home or whatever, or at home without regular contact. I mean, quite frankly, if those were the circumstances for a regular will, there'd be a lot of questions asked and a lot of concern about the circumstances that under which this will was made. So the very essence of our existence right now is in itself creating circumstances that otherwise would be, and maybe still will, give rise to a lot of concerns.
Yeah, and we just got a great question on that, and I want to talk a little bit about, just so that you, Suzanne and Jordy, know a little bit more, Jordy, about the other half of the special circumstances. Get some comments from Suzana. Then I want to recap the execution by counterpart parameters one more time, and then we're going to wrap up. But an interesting point was just raised in the chat, where a client has allowed his son to put an app on his computer to allow his son to assist him, similar to a computer help desk. And then all of a sudden it turns out that the son stays on the computer, looks around, looks at the files, looks at all of the information that's been set up, and the client, of course, loses trust in the son. And you can see how technology, in and of itself, even malware and things like that, can create other layers of possible influence or inappropriate behavior by beneficiaries and so on. So we're going to face a lot of widespread, it's not just jumping in a Zoom call. You're not invited to technology problems. Okay, so Jordy, why don't we just touch on the other half of the equation, and that is special circumstances and special issues with regard to family members, and how do we address those in a video intake or COVID intake situation?
So this is sort of our checklist for anybody, not necessarily even that they're going to be beneficiaries, but anybody, relative to the client, their family, et cetera. Some questions just to check through. Is there an estrangement with a family member? That's the first one. Obviously, that's very important. especially if they're a close family member who would otherwise be expected to benefit. Details about that estrangement are crucial. And maybe I'll defer to you guys on that.
Suzana, do you have any comments on these special circumstances of estrangement, disability, relationship difficulties, financial management difficulties, all of these sort of topics that are really important? It's not just the testator who may have a hearing impairment. It is what's around the testator.
Well, absolutely. I think that's really crucial because, as part and parcel of making sure that we are getting free and clear instructions from our client, we want to make sure that we're delving into all possible avenues of, inquiry. And so, if there is an estrangement, why is there an estrangement? How did it come about? And you're testing there for, reasonableness in a sense, and certainly, memory, cognition, the rationale for it. Disability, delving into, what kinds of disabilities do different family members have that might become necessary for the purposes of the plan itself, and, creating, for instance, hence and trusts if they're necessary. The relationship difficulties, I think, an easy one to really want to focus on because of the fact that, as lawyers, we're always trying to document and prove that at the end of the day, when we have to justify our conduct or the instructions of the client, that we have delved into things that might have otherwise swayed them to do things. And so all of these things are, even more important, I think, in this environment, particularly when, the alternative for all these people who are rushing to do wills now is to wait. And so if they are insisting on doing it in this circumstance during COVID-19, there must be a reason for it. And as a result of that, it just makes us amplify, I think, our inquiries or the reason to, really understand why it is that people are if they're, making significant will changes, why that is, or if they're doing a will for the first time, why it is right now. Those kinds of inquiries, I think, will just help us, substantiate what was going on at the time.
All right, and let's talk a little bit about the issues of financial management difficulties, the client residing with, residing with the client, and then receiving support. The other three issues there, Suzana.
Yeah, all great inquiries for the purposes of determining if there's going to be possibly a dependence relief claim at the end of this. The financial management difficulties, certainly, it will highlight the possibility that there could be some kind of reliance on others. And, you want to delve into who that is and why that is. If it's someone that they're living with, is there anything that amplifies that situation and causes a concern by the fact that perhaps they're cloistering, or they're manipulating, or they're perhaps even unduly influencing? And making those inquiries, having those discussions, I think, is really important. And receiving support from client, I think that's the easy one, that a red flag for a possible dependence relief claim at the end of the day.
So Jordy, of course, one of the struggles, and I will say, I don't think we're going to, in my view, is there's not going to be a lot of, when we come out of this, I'm not sure that there's going to be a lot of sympathy for the fact that we've all had to work harder and get paid less, because I would say judges are in the same spot. Everyone is, in some respects, who are trying to hold up the justice system. So, but we are notoriously undercharging for wills and powers of attorney. That's a reality. Now we're layering on all of these options and steps. What do you do, Jordy, and how do you manage these special circumstances in an efficient way, to sort of stem the tide of just piling on hours and hours of effort to do wills and powers of attorney in this unique situation?
I have, despite the more work and that kind of stuff, I haven't gone to the clients to say, it's going to be more. I typically, set a fee, and certainly for clients I've done who have started this process before this. Look, this is, I don't know. That's a business decision. Again, I'm not charging more to do that. But I can, look, we notoriously undercharge. We have to be careful that I mean, if you're watching the news, I mean, the online wills services are showing increases of 700%. You know, so I think we have to, as a profession, show the value that we add, you know, we can't just compete on price, because if we compete on price, it's always going to be cheaper to do it without a lawyer. So we instead have to show the value that we add, and the problems with, you know, trying to do it yourself. You know, this checklist itself, you know, proves, you know, most claims against lawyers are because of inadequate investigation without going through all these you know, checklists. And I can assure you that the online people don't do that. So, you know, I think we have to do a better job of that for sure, is educating people on what can go wrong with these things. And and charging a fair fee, and not necessarily, you know, trying to compete with the online $80 wills.
So just on that point, then, how do you use this checklist to bring some efficiencies to your day-to-day practice?
Well, it's a matter of, you can run through these things pretty quickly, and in most cases, the answer is going to be no to all of these things. The problem is that 1 out of, you know, 10, it's going to be, oh yeah, you know, John doesn't get along with Susan. They can't stand each other. Well, that's important to know when giving advice about who should be the executors and how you're going to deal with those things. Those are key questions. And so, but you can do it pretty efficiently, because, you know, especially if you're using a checklist where these are on the checklist for the client can give you a heads up. Yes, I am estranged from this person, or yes, you know, my son does live with me. And then you can concentrate. That's really where the value of our services lies, in exploring these issues and advising the client, how do we deal with them? That's really where we really should be spending our time, is on this stuff, and not on necessarily the generating the document or those kinds of things, which often, you know, is more rote stuff. So you can be efficient with this. Yeah.
Okay. So Jordy, let's just spend the last few minutes. We've got about 8 minutes left, 9 minutes left. I want to, between you and Suzana, I just want to recap now again where we're going with the video will steps that you're taking, and the presumed legislative change for counterparts. So maybe Jordy, you can just take a minute and talk a little bit about the steps you've been doing on just a classic video will intake and signing, and then what are we going to do when we layer on counterparts?
Sure. So I'm just going to screen share again for a second. And our blog sort of helps you on this. I've been sort of following this, that again, you want to make sure that the client is about to sign the right version of the will, and that the video conference is started with all 3 participants present. And I'm just going to maybe pull up the checklist that you guys created, and you know, making sure that obviously you're one of the licensees, so that's not an issue. And following this checklist. So, you know, noting the time, the date, identifying themselves, and then this is a pretty sophisticated, well, comprehensive, not sophisticated, comprehensive process where they're initialing and showing each page as they initial. I think obviously you have to decide how much of that is necessary. One thing that I've just been doing is, as the client is about to sign the final page of the will, I ask them to hold up the final page. Then I can watch them sign it, myself and the other witness. And then I have them hold it back up with their signature on it and acknowledge that that's their signature. That's that first part of that signing process.
Great. Keep going.
Yeah. Then the second video conference is when you get that original back from the client. This is if you're not doing counterpart, getting the original one back and then hopping back on a Zoom call with the testator And if both witnesses are there, that's great. And then following that same process where the testator can now watch you witness the will, which is required. And I do the same sort of thing, this, you know, holding up the last page, showing them that I've signed it and acknowledging it. That's less important than with the testator acknowledging it. But and then send it to the next witness. If you're going to do it, if you have 3 separate places, then do the same thing and have them hop on a Zoom call with the testator and do that. And following this checklist is a good idea, I think, just because then you've got a record of what happened if you're ever called to discuss, you know, what was the process. I don't know if you're recording it or not, but in case you're not, you know, this is, you know, and again, I think Suzana made the great point of strength in numbers. And if, you know, you're doing what everyone else is doing, then it's hard to say you're wrong, I think.
So now let's layer on, just to conclude this now, a counterparts scenario in the context of what you've just described. You're on mute.
A little simpler in the sense that you would each have your own version of the document, confirm that it's the same one with the same description on it, and then watch the testator sign. I would have them again hold up that last page and show me that they're signing that last page, and then holding it up again when they've signed it. And say that and acknowledge that that is their signature. And then next, the first witness would then do the same process, hold up the last page, sign it, and then acknowledge it, and then the third witness, and signing their each separate copy. And then I'd ask the testator and the other witness, I'd want to collect that whole document together, and then do the affidavits of execution, which would have the different copies as exhibits, I would say, to the affidavit. And I know that, Ian, you're working on affidavits of execution for that situation.
Okay, well, that's great. So we will have that as we monitor the legislative change. We will have that on our website as soon as it's live, and with both the checklist and some of the comments on the affidavit of execution. And we might do a short webinar just on the on a short notice basis on the legislative change if it comes about. So I'm anxious to make sure we stay within our time frame, and I want to thank everyone for joining us today. Suzana or Jordy, do you have anything else to add?
Nope, not really.
Okay. All right. Well, thanks everyone for joining us. We will be back. We will continue our weekly webinars, but we may be back sooner than later for a short one if it turns out that the legislation comes in and needs a little bit further explanation. But I think we're ready for counterparts legislation as well. So thanks everyone, and have a great day and be safe.
Thanks.